Mahon decision or with the Supreme Court reviewing the first, it's the First Circuit decision out of Massachusetts. So we'll see if anything happens in the near future. But as far as if Virginia is going to see one of these lawsuits, I really think that's going to be up to the NAACP because they are the ones who are really developing their understanding of how to bring these cases.
Rick?
Yes, who makes judicial appointments for the circuits in Virginia?
For the Fourth Circuit?
Yeah.
My understanding, please correct me if I'm wrong, but I believe it's the president makes the suggestion and then it's approved in Congress.
Well, generally, I mean, it depends upon the president's appointment. However, the presidents often give deference to the senators from that state, particularly from the same party. So clearly, in terms of the Fourth Circuit, appointments of people from Virginia, President Obama will look to whether or not Mark Warner and or Jim Webb approve of particular nominees. So one of the problems, by the way, and you could all weigh in on this, which is just kind of underreported, is the number of vacancies on these courts, including the Fourth Circuit. And that what that means is that the holdovers from previous administrations are there, and if Obama doesn't get through his appointments by failing to nominate, by not having these people confirmed, then you can see that the law may have a harder time getting changed because you still have the Bush appointees, dominating the court. And the Fourth Circuit, there's several vacancies.
There are a
lot of vacancies. So President Obama does have, if he gets his nominations in and he gets them approved, has a substantial opportunity to change the political makeup of that court.
Yeah, I think it would just, if he changed it, it would just be closer to the center as opposed to being a little more conservative.
Right. I mean, change it so that, for example, a case like this, a voting rights case, would be seriously considered instead of dismissed.
Yeah, this technically came up one time in the Fourth Circuit about 10 years ago, I believe. I believe it was a pro se prisoner case, and it was unpublished, fortunately, so it's not binding. But the court did seem to indicate it's not very, it's not going to rule very favorably on it, if this is the current makeup of the court. So you would have to see some changes before it would be viable here.
But the good news is, since these cases take a long time to work their way up to the Court of Appeals, that hopefully, if President Obama gets 3 or 4 appointments to the Fourth Circuit, by the time it reaches the Fourth Circuit, if the case is brought, there may be enough judges who would take this issue seriously. But that's something that's not going to happen this year or next year, for sure, right? We're not going to have a federal court overturn Virginia system in the next couple of years.
No, I think the real focus right now is to see what happens in the Ninth Circuit. I think that's going to be the one that may clear the way in certain respects for Virginia. And it's important to note that even if in Washington State their law isn't overturned, because it focuses on prisoners' ability to vote, which is different than our problem here. They could make some rulings in that decision which could still be favorable to Virginia, even if they rule against the prisoner. So it's a bit of a strange situation because it's different, but even if they get a bad result, that could be a good result for us, considering how bad our law is. So,
anybody, Brian?
Yes. Let me get to understanding now. You said the prisoners in Washington State brought the case.
First 4 years, nothing happened. They brought this in 1996, and so nothing was going on for several years until they were finally able to get connected to the NAACP, and then it really started to move at that point.
Is it possible, say, a different organization can start up than here, rather than wait for NAACP?
It's possible. The big problem is you want to see these 2 other cases resolved, and so right now it would not be appropriate, I think, putting it while these are pending, because you want to see how the precedent falls. You want to see how courts are deciding this today.
Yeah, let me also address this, because I was a civil rights lawyer for 35 years, and one of the really important things in developing civil rights law is the general tenet that bad cases make bad law. You don't really, like when Thurgood Marshall, he didn't just bring Brown versus Board of Education. There were a series of cases that sort of set it up. So you got to be careful to make sure that you're bringing a case that's properly prepared in an order in which the courts are going to be more receptive. So therefore, you want to have it done carefully rather than just somebody, throw up a case. Because basically, as Howard was saying, based on the evidence that's prepared in the preparation, often has a lot to do with the outcome of cases. And you want to make sure it's much better to be well prepared and have the case take a little longer than have the case not as well prepared or not, with the right stage and get it thrown out, because that then sets everything back. So, this should be done carefully, certainly in Virginia, because Virginia is not fertile territory for this kind of thing.
And it would also take a lot of money. No matter where you bring this case, it's going to be very expensive litigation. You need to hire a lot of experts, and they have to be really good.
Have there been, Howard, any attempts to bring legislation challenging the Virginia provision in Virginia, in the state or federal court?
Yeah, there was one challenge, and it was handled in an unpublished decision. Again, it was Howard v. Gilmore. It was just a pro se prisoner who did a pretty good job drafting the material to just lay out the issues. Obviously, he didn't have expert witnesses to help him support what he said, but the court was able to deal somewhat effectively with the idea that it was based purely on racial discrimination. One of the things they cited is the 1830 Virginia Constitution, because even prior to the 15th Amendment, we've always had criminal disenfranchisement in this state. So it's something that it's difficult to prove just on that provision alone. It's more you would have to show that there was a significant discriminatory effect of the law on different races. And so one of the things that would make that difficult in Virginia is, if I were going to be the Attorney General of Virginia, the experts I would hire would be the ones who would say that this has nothing to do with race, has everything to do with economic class. So if you just look at it based on who's getting convicted based on their income, that might be the real problem here. And so if they get enough experts and they just continue to put money to that side of the argument, it's going to make it really difficult for a court to rule which side has the better argument. And since the people challenging the law are going to have the burden of proof, it's going to be much easier, I think, for Virginia to undermine this litigation without really good and very expensive expert testimony.
Rick?
The states that have turned this around recently in the last 10 years, has that been mostly legislative or judicial, or how did these other states succeed in reversing this discrimination?
Well, I think it's a combination. I don't know. In Maryland, there was really a citizens movement to change the law. In Florida, where you had the Republican governor, did it by executive order, like we were asking Tim Kaine to do. Charlie Crist restored about 150,000 people the right to vote in Florida by executive order. I guess
Washington actually changed theirs. It used to be a permanent ban, and now it's just if you're still in prison. So Washington is a state that did it by legislation.
I think what we're talking about, if your question, just to go a little deeper into that, when we had this thing in November in Lexington at Howard's Law School, see, it's your law school now, at Washington and Lee, we basically concluded, we explored the four avenues. One, getting the governor to issue executive order, federal legislation, state legislation, and litigation. And basically came to the conclusion, I think, we can all talk about it, we're probably still at the same conclusion, that the least likely is litigation, and followed by the second least likely would be the state legislature. And the most likely avenues at that time were executive order by the governor or federal legislation, none of which are necessarily likely, but all of them would take hard work. But federal legislation, which we'll address in a bit, as well as state legislation, have much, even though they may not have a great chance right now, they have much better chance of ultimate success than litigation in Virginia. Do you think that's a fair statement?
Yeah, and I'm a little worried about actually the First Circuit case that could go to the Supreme Court, because that could actually hurt the chances of changing the Virginia law through the federal court system. Because that First Circuit case deals with people who are presently in prison, I would be afraid that if the the Supreme Court got a hold of that, they would start talking